Most interviewers know it's unwise to make a hiring decision without first checking an applicant's references and, in many instances, conducting a thorough background check. Despite well-honed recruiting, screening, and interviewing skills, even the most seasoned interviewers feel uncomfortable extending a job offer without more closely examining information about the person selected. Reliance on references and background checks has increased, due in part to concerns over charges of negligent hiring and retention. Employers conducting reference and background checks need to be able to distinguish between two forms of information gathering and consider relevant legal guidelines. Let's take a look. References probe an individual's work and education-related background. The primary purpose of any reference is to 1. Verify information provided by the applicant throughout the application process, and 2. Establish job suitability. Reference checks also allow potential employers to view would-be hires through the eyes of former employers. Background checks explore aspects of an individual's background that have nothing to do with previous jobs or education and are more personal in nature. Typical areas of focus include criminal records, medical records, and workers' compensation records, along with credit reports. The extent of pre-employment background checks should relate to job-specific requirements. For example, conducting a Department of Motor Vehicle or MVR investigation would make sense when hiring a crane operator, but would likely not be appropriate when hiring a secretary. Most employers conduct reference and background checks only on those applicants that they're interested in hiring. Since background checks are often conducted by outside vendors for a price, businesses bystep this step and focus on HR-conducted references. Employers are advised to familiarize themselves with certain legal guidelines, including on the state level as they relate to reference and background checks. State laws differ as to what a potential employer can consider with regard to criminal records. Some states, such as Colorado and Connecticut, require a connection between a job and a crime committed before an employer can refuse to hire the individual. Illinois, Maryland, and others will not consider convictions that have been expunged or sealed. And Hawaii generally requires that a contingent offer be made before ordering criminal records checks. Employers are protected by the common law principle of qualified privilege. This doctrine is premised on the public policy that an exchange of information relative to the job suitability of individuals is in the best interest of both employers and the general public. Consequently, if such information is defamatory but without malice, it may be deemed privileged. The number of states with reference checking laws is increasing. These laws protect employers that provide good faith job references of former and current employees. This added protection enables employers to give and receive references that go beyond the typical play it safe policy of only verifying dates of employment for former employees. Even with such legal protection, however, the trend is to proceed cautiously, providing only documented information that can be easily defended in court. Despite the degree of protection afforded to former employers by common law doctrine of qualified privilege and individual state laws, many still fear liability and hesitate to provide references. The result has been increased lawsuits based on negligent hiring and retention. The only effective defense against charges of negligent hiring is a complete investigation of all job-related facets of an applicant's employment and educational background prior to employment. Background checks of previous convictions and driving record violations may also be deemed appropriate depending on the job. This represents quite a dilemma for employers. Former employers can be sued for defamation when providing improper references, and prospective employers can be sued for negligent hiring if references are not properly checked. Some employment experts suggest a possible solution, requiring job applicants to sign waivers, relieving former employers of liability if the applicants are not hired due to unflattering references. While conducting reference or background checks is at the discretion of the employer, compliance with the Immigration Reform and Control Act of 1986 is required by law. The Act prohibits all employers from hiring illegal aliens. More specifically, it requires verification that all individuals hired after November 6, 1986 be legally eligible to work in the United States. Such verification comes in the form of the Employment Eligibility Verification Form, commonly known as the I-9. The I-9 expressly requires new hires to provide employers with documents that confirm their identity and employment eligibility. The I-9 form has undergone several revisions since the onset of IRCA, with the most recent changes coming in 2009. These modifications include a requirement that employers accept only unexpired documents. When it comes to references, most employers have been on both the giving and receiving ends. When contacted about a former employee's work performance, they're probably stingy with information, but when trying to get information, they want to know everything possible about a potential hire. It would be ideal if every employer worked from the same set of guidelines governing both the release and the collection of information. That way, everyone would be abiding by the same rules. While that's not likely to happen, you should set up a set of workable guidelines for your organization's reference check procedures. When it comes to releasing work-related information about a former employee, consider these guidelines. One person, or a limited number of persons, should have the responsibility of releasing information about former employees. During exit interviews, tell terminating employees what information will be provided during a reference check. Try to obtain a signed consent form from the terminating employee authorizing you to provide relevant reference information to prospective employers. Always tell the truth and make certain you have documentation to back your reference up. Make certain that the person to whom you're providing reference information has the legitimate and legal right to it. Be certain that all information provided is job-related, and do not volunteer information even if it's job-related. To increase your chances of obtaining meaningful information about potential employees, consider these guidelines. Conduct all reference checks in a uniform manner. If an applicant is ultimately rejected because of a negative reference, be prepared to document the job-related reason. If, while conducting a reference check, you discover that the applicant has filed an EEO charge against a former employer, keep in mind that it's illegal to refuse to employ someone for that reason. Obtain permission from applicants. Carefully question the validity of comments made by former employers. Exercise caution when interpreting a respondent's tone of voice, use of silence, or implications of what is said. If possible, check with a minimum of 2 previous employers to rule out the possibility of positive or negative bias. Ideally, the person who interviewed the applicant should conduct the reference check. Do not automatically assume that a reported personality clash is the applicant's fault. Having been fired does not necessarily mean that an applicant is a bad risk. And finally, tell applicants that any job offer will be contingent upon satisfactory reference from their current employers. The Fair Credit Reporting Act is a federal law enforced by the Federal Trade Commission. It pertains to a great deal more than a person's credit history. FCRA governs the acquisition and use of a wide range of background information on applicants and employees. FCRA defines consumer report as a report prepared by a consumer reporting agency that investigates an applicant's or employee's credit, character, reputation, personal characteristics, or mode of living. Examples of consumer reports include criminal background investigations, Department of Motor Vehicle inquiries, and credit history checks. The information is gathered and used for employment purposes, defined as hiring, termination, reassignment, or promotion. The report must be then prepared by a consumer reporting agency to qualify as a general consumer report under FCRA. In some instances, drug tests may also qualify as a consumer report. Employers are obligated to comply with these steps whenever they request a background check or investigation under FCRA. 1. Employers must provide applicants or employees with special notice in writing that they will request an investigative report. They must obtain signatures of consent. In addition, employers are required to present a summary of the rights under federal law and FCRA. 2. Employers must certify to the background check or investigation company that they will comply with applicable federal and state laws by signing a form typically provided by the vendor. 3. Employers must provide a copy of the report to the individual investigated if an adverse action is to be taken. Employers should include a description of the adverse action, which could be, for example, withdrawing the offer of employment. Employers are further obligated to wait a reasonable period of time, generally 3 to 5 days, before taking adverse action to allow individuals investigated time to dispute the accuracy or completeness of any information within the report. 4. When hiring the services of investigation companies to conduct background checks, employers must ensure that the agencies are aware of prevailing laws. And 5. In addition, employers need to ensure that these agencies do not reveal information that are entitled to disclose. For example, agencies are not permitted to divulge information about bankruptcies that are more than 10 years old or tax liens that exceed 7 years.